This program is brought to you by Emory University.
My name is Angela Campbell, and I'm a law professor at the Faculty of Law at McGill University in Canada. And at McGill, I teach and I research in the areas of family law, health law, criminal law, and wills and estates. So before I started teaching in law, I actually practiced for a very short period of time at a very large law firm. And while that work was extremely interesting and challenging on many levels, I also knew that for my own interests, it wasn't going to be sustainable. And particularly, my main goal was to try to work in a research context. And I liked having a lot of ability to determine and control for myself the areas on which I learned and did research, which you don't necessarily get to do when you're working in private practice in a firm. One of my former colleagues, when I was clerking at the Supreme Court, she is a law professor at the University of Ottawa. And while I was practicing law, a position came up at the University of Ottawa for a short-term position. And she asked me if I wanted to apply, and I did that, and I filled that position, and it was great because I had an ability to kind of get my feet wet as a law teacher in a small class context. So I taught criminal law to a small group of students, and I loved it, and I realized that the part of being a law professor that I really enjoy the most is the teaching component. So the research is great, and I love doing the scholarship, but the teaching is fantastic because the people with whom I'm engaging every day in my classrooms are bright and energetic and have these amazing ideas and this interest, this intellectual curiosity that is just so energizing. And so it fuels my own interests and ambition. So that's a really good question, and it's tough to answer because my interest fields are kind of in different areas. If I had to say what the current that's running through all of them is the notion of human relationships, especially intimate relationships and family relationships. So when I practiced law, I worked in a business context, and I felt like the one thing that was missing from the work that I was doing was the human element. So there wasn't really a lot. I mean, human relationships underlie almost every either legal conflict or legal transaction, but what was missing for me was the element of human contact and human emotion. And I'm very interested in the way in which human emotions drive decisions that have legal implications. So, for example, I'm very interested in the way the law thinks about marriage, for example, and thinks about the relationships between parents and children. And I had done some work in the area of children in the law. So that particular interest in thinking about our interactions with one another, but in an intimate context or a family context, is what drove me to think specifically about family law. And it ties in also into wills and estates. And feminist legal theory has had a lot to say about these areas as well. And it comes up also in connection with health law and criminal law, because the work that I've done in those two areas links up very much with family law. So thinking specifically, for example, about in the health law context, the way in which the law governs assisted procreation, so assisted reproductive technologies, and how we form families and use medical and scientific developments to fuel our ability to form families in different ways and to have children in ways that are outside what we might think of as the norm or the kind of orthodox method of forming a family. And in connection with criminal law, I've thought a lot about the law's treatment of families or relationships that, again, are considered unorthodox. And that's what brought me to the project that I'm working on right now. Sure. So the project that I'm developing right now is a book project. So I'm writing a manuscript and the book is called Outlaws by Choice in the form of a question. And the book interrogates whether or not the notion of choice has a meaningful role to play in assessing the way law interacts with or reacts to controversial lifestyles that women adopt. So that's a complicated way, or maybe a kind of convoluted way of saying that I'm interested in thinking about the law's criminalization of particular kinds of lifestyles that women engage with. And so I'm using 3 case studies, one on polygamy, or women who are in polygamous marriages, one on surrogacy, and women who become surrogate mothers for other families, and the third is on prostitution or sex work. And in each of those contexts, women are arguably making a choice to engage in morally ambiguous or controversial practices. But the problem with using the notion of choice is that it sounds as though that they're then acting with complete volition or freedom, when in fact they're often operating within severe constraints that force them or propel them to take up these practices. And the idea of choice also is problematic if it connects to responsibility or volition, because what happens with respect to the law is that the law says, well, you've made this decision or this choice knowing that it's prohibited, and so now you're going to bear some criminal consequences for that. And so the women in turn are either subject to penalty in the form of some kind of criminal sanction, and they're also stigmatized heavily for these situations. So my project then aims to consider the problematic aspects of using the notion of choice in these contexts, but also the problematic aspects of saying that there's no choice, that women are always operating under some kind of oppression and being driven by external forces rather than making kind of exercised and deliberate judgment calls. And that's kind of what ties into the notions of vulnerability that have been so central to the project that Martha Fineman's pursuing. Martha Fineman's work has always been quite persuasive to my mind, and the vulnerability thesis that she's been developing over the last few years has been especially important to the work that I'm doing. So the notion that vulnerability doesn't attach to particular groups of seemingly marginalized people, but rather that vulnerability is actually part of the human state where we're all at, and that it's a shared and universal way of being, is really important to my own thinking about women, because I see that there are particular problems with locating vulnerability to particular groups. What happens is we either pity those groups, or we say that they need to be saved, and in doing that we take away some of their autonomy and recognition of their human capacity. So I've been very persuaded by that thesis about vulnerability as universal and as shared and as constant. And so I very much wanted to have the contact at an intellectual level and personal level with Martha Fineman. And she's also the editor of the series that's published by Ashgate Press, which is where my book is going to be published. So Martha was already familiar with my project. So it made sense for this time to be spent here. And I also knew some people who had come here to spend some time in the context of the VHC FLT project, some Canadian scholars, some American scholars, and they had all spoken so highly of their experiences and had felt that they were able to both make some kind of contribution by being present here, but at the same time leave here with incredible feedback that really nourished the projects that they were each undertaken. And so my time here is very short, unfortunately, but even in the short bit of time that I've been here so far, I've had these engagements with various colleagues and students and postdoctoral fellows who've really helped me in tremendous ways to think about some of the different ways in which I might think about the work that I'm doing right now, but also future projects. I think I'll always be working on issues related to families and children and feminist legal theory. I'd like to shift a little bit away from the criminal law, I think, at this moment, and look at the area of estates and inheritance I think that's an area of law that has been really under-theorized, and it's treated as, a lot of students see it as a very kind of dry area where we imagine the law of wills and estates and the doctrines of successions law as being very kind of formalistic and black letter, in the sense that they're very cut and dry. But I've taught this course at McGill for 5 years called Wills and Estates. And my goal now is to teach a course that integrates the law related to successions from different legal traditions. So I want to integrate Aboriginal legal traditions into thinking about wills and successions and the areas of inheritance. And I'm also interested in taking up research that thinks about the way in which women perceive both their duty to leave property or legacies to their families or other people in their networks, and also the way in which they see their rights of inheritance, and to think about how that compares with the way in which notions of inheritance and transfers of property on death have been traditionally understood. So again, using feminist legal theory to develop ideas about care and responsibility and family connection through a feminist lens, which hasn't really been done before. So that's the work that I want to do going forward.